Welcome to Rebel Chaser. My name is Gail, and I wanted to do something a little bit different just to say goodbye to 2023 and hello to 2024. So I was going to do just kind of a recap of some of my more shocking or interesting cases. And I'm going to just go from one to the other. I'm not going to cut in, but I am going to just put up a little thing just saying, what the name of the video is. So if you wanted to find it to watch that, the whole entire video, you could. So anyway, I hope you like it.
Case is not going to go.
You said, what's that, Judge?
You want discovery on the case that's not going to go.
Not even that we want discovery on the case. Judge, what is the remedy? Because this keeps on happening. So rather than wait until the last hour or even having to wait hours before to get the discovery and then say, well, you got the discovery, so what can you do?
One at a time. I'm talking about this case.
I'm talking about this case also, Judge.
Discovery on the case that's not going to go. Is that what I'm hearing?
Can you say it again?
For the fourth time, we want discovery on a case that's not going to go.
Let me choose my words. I wanted discovery on the case that was scheduled for a preliminary examination at 12 o'clock today. Well, we don't know if it'll go, because what if the complainant just so happens to walk in? Rather than waiting last hour and we keep on doing this,
Okay, please don't talk over me.
I'm not going to talk over you, Judge.
He's still talking over me.
Well, you're cutting me off.
When I talk, you stop. Understood?
No, I actually don't understand that, Judge.
Why don't you come down here and I'll make it clear to you. Come down. I'll see you at 12 o'clock.
I'm not coming at 12 o'clock, Judge.
Okay, don't come then and see what happens.
Okay, so do you want Attorney Davenport, who is the attorney on this case? Do you want to speak to him? Because if you're asking me,
why are you even talking to me if you're not on this case? I don't even want to talk to you then.
Well, you asked a question about me, Judge, so I started speaking.
You're talking to me if you're not involved in this case.
Well, I am involved. I'm co-counsel on this case, Judge, but just to be...
I want you to come down here at 12 o'clock today.
I won't be coming, but here's Attorney Davenport.
And I'll hold you in contempt of court.
And I'll go ahead and file a grievance.
Do it.
I will.
I don't appreciate any yelling. I feel like it's unprofessional. I feel like she was trying to express the fact that this...
And I asked her not to talk over me, Mr. Davenport. Just like you stopped when I started talking, I expect the same from her.
Just as this happens in other cases, we expect discovery in a timely fashion so we can represent our clients in the best way possible. So as these cases become moot points of discovery, we would like to be able to have a situation where if the complaining witness does show up, we don't have to wait till the last minute. We can either hold the exam or not. We started off asking for discovery in court. We were told we have to submit a discovery order. We started submitting discovery orders. After we submitted discovery orders, we were told we have to keep in communication to remind prosecutors that we have to get our discovery as they're obligated to provide us with. After that, you told us if we were in communication, then we should file motions to compel. We keep trying to do and be proactive. And we're trying to explain this problem right now, but there's no reason.
Mr. Davenport, if the witness was to show up, there's no way I would make you go forward on the case that you just received discovery on today. Period. Now, let me talk about what I don't appreciate. I don't appreciate being talked over. I don't appreciate when I'm trying to make something clear. Ms. Davenport indicates that she didn't understand. I told her to come down here. She told me what she's not going to do. I ordered her to do so. So understand that grievance process works both ways. I can file a grievance as well.
And so in this situation where she's trying to get the case dismissed before 12 o'clock because we wouldn't be holding it whether the complaining witness shows up or not, and we're trying to be efficient with our resources.
I'm not inclined to grant a dismissal when discovery was given to you, although it was not given to you timely. I'm not inclined to dismiss based on that.
What would be the future? What would be the remedy for future reference?
What future reference? What are you talking about?
So in any other case, in a situation where we submit a discovery order, keep in contact with the prosecutor, submit a motion to compel, and the
I take
discovery
it case by case basis, sir. I can't tell you what I'm gonna do in the future.
Oh,
How do we
okay.
know how to comply?
I mean, so we just have to keep.
You're not gonna comply anyway, Ms. Davenport.
I'm sorry, Judge, I didn't hear you.
You told me you're not gonna comply with the court's order. I ordered you to be here at 12 o'clock. You told me you're not doing it.
Judge, I can't come down there at 12 o'clock today. But when you see me on another hearing, or if you want me to come down on a different time, then we can definitely discuss it. In fact, I know that is this recorded? Because if this is recorded, then we both can use it in our grievance. But Judge, you asked me a question. I started answering. You cut me off, and then you said, when you start talking, I stop. I'm not a child. I'm not a puppet. I don't disrespect you, and I expect to be respected as well.
I expect you to respect this court.
I do respect this court, which is why when you ask a question, Judge, I stepped in to answer your questions.
I
don't like to talk over people either, Judge. It's just that when you ask me a question and then I'm answering it, when you're cutting me off, how do I know if I'm answering your question? When am I supposed to stop or not? If you want to speak, then I will be quiet so that you can speak. And then when you ask me a question, I'll answer your question. Oh, I'm sorry. You want to speak to Attorney Davenport?
Ultimately, Judge, in this situation, which was a similar situation as last week, and I understand it's unpredictable and we can't really determine what you'll do based off past action. But last week, when the complaining witness didn't show up and the discovery issue was moot on a different issue, I appeared in court physically. Now, that wasn't a requirement for the prosecution as they came in on Zoom, and I have no problem with that because it's an efficient use of resources. However, I don't agree that it's an efficient use of everybody's resources if we're not going to hold this exam to have us continue to come show up in person. We're doing all this back work trying to make sure we're prepared. So we prefer to appear on Zoom.
I don't have an issue with that.
Okay, thank you.
The prosecution is indicating that the witness is not going to appear.
Very well, Judge. Would you like us to appear at noon?
That's what time the exam is scheduled.
That's true.
So you don't want you to address discovery issues in advance no more?
Won't be able to tell. I gotta wait for the next case. Okay, so we will appear back on Zoom at noon for the dismissal. And I'll see you then, Judge.
Did you get printed the other day at Woodhaven?
Yes, I did, Your Honor, because you told me to.
Right.
Yep. And I didn't know I had a tether violation, and they arrested me. And also, I need to pay a ticket
Slow
today.
down. Slow down.
Sorry.
Slow down. Let your lawyer speak.
I see a warrant. I see he was picked up on a warrant while being fingerprinted out of the Third Circuit in Wayne County.
Do you have is there a deputy right there?
Yeah.
Deputy, can you come back up here, please, and state and spell your name for me?
My name is Officer Marquise Rigel, Marquis. Last name Rigel, Ridgell.
Thank you. Mr. Elliott was picked up on a tether violation, it says, on the 4th. For the life of me, I cannot figure out what the tether violation is. I read this record, this report here, and it says that he was over there lurking at the police department.
He's being fingerprinted.
I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven Police, did verify subject was there. A detainer was emailed. I was notified the subject was at Woodhaven Police to be fingerprinted. The Third Circuit warrant was found and the subject was put into EMU writ status. So this has nothing to do with him. Him being in custody right now has nothing to do with a tether violation. Is that true or false?
I'll have to look, sir. hold on.
I don't see any reference in there about a tether violation.
Well, it says it in here, there was, I mean, implicitly they say it, but I don't see where there was one. I didn't order him not to go back to the Woodhaven Police Department. I think he was picked up on another warrant.
There is reason to believe, and I'm going to state it, not my client. And Mr. Elliott, I don't want you to say anything because you haven't pled guilty to anything and you're presumed innocent. I have reason to believe that maybe there was a battery not charged when he was at home. That may be an issue.
Excuse me, Your Honor.
Yes.
According to the system, it says he's here for malicious destruction and 2 counts of domestic violence. Now, about that report or being a violation of his tether, I would have to even read the report myself, sir. I didn't write the report.
Can I speak?
You're just, Elliot, I want to make sure you don't say anything that incriminates you because you haven't pled guilty to anything.
I know I've been told 4 different things that it is. Like, I don't know what I'm
That's fine. What is it that you're being told?
I'm being told from the sheriffs that picked me up from the Woodhaven Police Department, it was a tether violation. Then when I first asked the Woodhaven Police Department, when I first got there, they told me it was a stalking charge. I've never stalked anybody. Then now it's a malicious destruction of property, which I'm paying off. That's from another case at Woodhaven that I'm paying off. And I need to pay that ticket off today as well, which is another problem for me, but that's beyond the point. So basically, I'm very confused. My tether got it. I know it's a tether violation, but I don't know. I'm sorry, Your Honor. I'm not trying to confuse you.
All right, slow down. Just relax.
We're all trying to figure it out together.
Take a deep breath and relax.
I did represent him on the one with the malicious destruction of property. It was a vehicle.
Lisa, there is a note here, malicious destruction of property. It says malicious destruction, signs, bills, or notices. It says he has a, to Judge Hessen?
Correct.
Yes, I handled that file.
Was he on, is he in custody on that one? I cannot figure out why this gentleman is in custody.
I have a job.
Mr. Elliott, I'm going to straighten it out for you, sir.
Thank
Okay?
you. I'm really thankful.
He's working 2 jobs. He's stressed because he's going to lose his job.
I just lost my old job because I got locked up.
All right, settle down. I'm going to help you. Okay? Assuming you need the help or assuming you're deserving of the help.
It doesn't look like he's on a tether for Judge Hessen's case, so there should not be a violation for that.
I don't understand this. I just don't understand this. They're saying at approximately 6 p.m., 1900 hours, or 7 p.m., I guess that would be, while monitoring the OmniLink software, I noticed the above subject tracing the location of the Woodhaven Police Department. I contacted Woodhaven and did verify the subject was there. This is a sergeant from the sheriff's tether unit. The detainer was emailed that I was notified the subject was at Woodhaven to be fingerprinted. A Third Circuit warrant was found and the subject was put in the EMU writ status. So I don't know what the Third Circuit warrant's on, but that has to be the reason. But I'm just curious as to why they're putting him in front of me on a tether violation when it appears there was none. The subject was in compliance with his curfew at the time of the arrest. Unless the tether violation is for violating a law, and that could have happened while he was on bond, and I ordered him not to violate a law. So I'm unclear. Do we have any other indication that this gentleman was picked up on any other case after he was in front of Judge Hessen, actually, for arraignment on February 21 of 23 and up through the present? And I see nothing.
The Wayne County site only shows these 2 cases.
Excuse me, Your Honor.
Yes.
Again, this is Officer Rigel again. I just got off the phone with the coordinator, and Officer Caribbean was stating that in the report, it should have said something about him violating due to police contact.
Well, that could, hang on, Mr. Elliott. But nobody's telling us what the police contact is. I don't know what the Third Circuit warrant is. I'm looking at his lien. Now, granted, this one is dated March the 28th, so maybe you need to update that, Lisa. But I don't see anything on here on his criminal history indicating any other charge emanated after the February 21 of 23 incident. So why don't you start by running his lien again, an updated version? I know it's only 8-9 days, but
Can I say something real
maybe
quick?
that. I'm sorry?
Can I say something real quick?
Sure.
I'm wondering if they think he was there getting printed on new charges.
Well, that's Mr. Elliott, would you please stop? I ordered him that day, Deputy, to go and get printed at Woodhaven Police Department. He hadn't done it previously. I ordered him to go over there and get printed. That's why it was at the Woodhaven Police Department, because on this domestic violence case that I have that has an offense date of January 27 of 23, for which he was arraigned on February 21 of 23, I noticed when he was in court on April the 4th that he had not been printed. So I ordered him to go over there and get printed, and I set this for a bench trial. Then they're talking about on the Tether violation that he was at Woodhaven PD. I think there's been some. I think there's been
a misunderstanding, Your Honor.
So do I.
Your Honor, I'm going to ask
Wait, do we have any indication that he has any other case pending in Wayne County Circuit Court, Mr. Deputy Marquez?
No, sir, not that I see. None but the current stuff.
Lisa, do you have any indication on anything, including the lien that you're either have run or are running or about to run, that there's any other hold?
No, the lien is printing down there in the courtroom right now. And I looked on the Wayne County site. It only shows these two cases it's held on.
So the problem is somebody had made an assumption, and my father used to tell me what would happen if you made an assumption. And it's not a good one. This guy's been he's been sitting in jail for 2 days. Unless there's a hold, I want him released immediately.
Thank you, Judge.
Okay?
No tether?
Well, no, he's still going to have his tether. I still want the tether on him. Wait.
Yes, Judge.
I want the tether on him still with the same tether conditions. And we will send those back if we need to. No contact with Isabella Cavallan or prosecution witnesses, no alcohol, no drugs, no firearms, no dangerous weapons. He's not to be within 2 miles of that individual's residence or place of employment, and he was not to be released until fitted with a GPS tether. So what I would like is, do you still have the tether right now, Mr. Elliott?
No, they cut it off, Your Honor.
So they need to get that back on him with those same conditions. And would you tell them the judge would really appreciate it if they would expedite it, since he's just spent 48 hours in jail, or if thereabouts 38 hours in jail that he shouldn't have spent 38 seconds on?
Yes, so, I'll get with my sergeant ASAP.
So Lisa, let's send that back. The minimus, we'll just do an amendment and say the defendant has posted bond, because he has February 28th of 23. I'll just make a note, and then you can put in the conditions to make sure they get all the conditions in here. Defendant taken into custody on April the 4th. It appears that was in error. Defendant to be released immediately, but I need you to have those. But this is not right. Look, they got to be more careful down there. I mean, this guy now, he spent 38 hours in jail. I wouldn't want to spend 38 seconds in jail, let alone 38 hours. Now, he's got himself into trouble, but he still enjoys a presumption of innocence here. And now somebody's going to tell me they can't get the tether back on for a day or 2 or 6, and that isn't right either. So do whatever you got to do. Tell him the judge said he wants this guy fitted with the tether first and foremost right now, as soon as possible, so he can get out of there, because he should not have been in custody for the last 38 hours, as far as I can tell.
Thank you, Judge.
I'm gonna give my sergeant a call right now.
And if they need to talk to me, they can call the court and I'll talk to them. But you got to be careful. Thank you very much, Deputy. Have a good day.
Thank you, Judge.
Thank you, Mr. Baldwin.
Thank you, Your Honor.
Thanks a lot, Mr. Elliott. Stay out of trouble, though.
I will, man. I'll talk.
I don't want you to say a word. Shh. Stay out of trouble. Don't say a word. Good luck.
Yes.
I'm trying to get them out of breakout.
All right, so you're Paul Bull, and it's Paul Thomas Bull. Just want to make sure the record's clear, since we've got your father with the same name that's been in here. Mr. Bull was previously in court, entered pleas of true to counts 1 through 5 and a motion to revoke unadjudicated probation. And then the case was reset for sentencing. I got an updated report. Since that time, a first amended motion to revoke unadjudicated probation has been filed, and we need to go through. It added count 6, which was the allegation of leaving the state, which I think is important. So let's do this first. Mr. Bull, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Sure. All right, thank you. You can put your hand down. So we already went through the initial motion. What you're on probation for is stalking. You were placed on probation November 5th of 2018. And this first amended motion alleges in count 6 that you also violated your probation by failing to remain in Jefferson County, Texas, as ordered, and that you were in the state of Alabama on July 18th of 2023 without permission. Is that true or not true? So did you enter your plea of true to count 6 also freely and voluntarily? And because it's actually true. All right. So I will find count 6 true, as well as counts 1 through 5 in the previous true. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor. I have one.
Are there any additions or corrections? Hang on. I'm like your attorney. I'm asking the attorneys right now.
Unless my client has something to add, I reviewed it with him.
Okay. Ms. Malfino?
Other than just a very brief argument, Judge, whatever.
Right. So is there something that's wrong in the report?
No, I have read this, but I know obviously I've made mistakes and read the letter, so I really want to make it clear about any type of intentions I've given in the letter. 100%, I'm not trying to manipulate you, the system, and I wasn't trying to. Being previously, how I messed up with telling how I knew about the wedding and all that stuff. I wasn't there to cause any problems. I don't know if they're asking that, but I just want to be clear about it. I had no intentions of harming anybody, because I know.
Well, what were you going there for?
I didn't know where I was going. I started off in West Texas, then went north, East Coast.
Well, you didn't randomly,
I'm just saying.
All right. I don't believe that you randomly ended up in the same place.
He couldn't have gone to West Texas from.
We had him on the license plate readers the whole time.
Monitor off, and we were notified.
Hold on. Look. Just
Went
stop
straight
talking.
to Alabama.
Unfortunately for everyone involved, the least of which was me and Ms. Malfino, we were all up and concerned, so concerned about what was going on when you cut that monitor off and you took off at a high rate of speed and went straight to Alabama. So you can just stop with whatever else you're talking about, because it makes no difference, because you are trying to manipulate and you are lying. So I don't really, I've dealt with this for as long as I've probably dealt with almost any case. Y'all can make argument, but I know what I'm going to do.
I mean, because I've done the monitor before successfully, and I'm under less stress now with doing more or less hours of work.
Here's the thing, Mr. Bull. The only thing I wish today is that I had a higher range of punishment, because I want for Claire to have some sense of peace for as long as possible. And unfortunately, I can only give her a short amount of that. And that's what I'm going to do. I'm going to hang on. I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and I find you guilty of the felony offense of stalking. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit for any time that you've been in custody that the law gives you the right to receive. This is not an agreement, so you do have some rights to appeal. I need you to sign that with Ms. Holmes real quick, and I will give you a copy of that admonishment telling you that you can appeal. You're also, y'all can go ahead and sign it now. Yeah.
How did they know that I had started going towards West Texas?
It doesn't, there were license plate, there's license plate readers on the Mr. Bull. There's license plate, don't interrupt, okay? So all over the United States now, there are things called license plate readers. They put in a license plate, and when something like this happens, they can start tracking. And that's exactly what happened. And that's how the state of Alabama and the people there knew to be looking and try to find you, okay? You don't need that. I need you to hang on, stop talking. I need you to sign that document so that it just says that you're getting a copy of it, and you have the right to appeal is all that says. If you'll sign it, please.
Judge, may I just ask, and I don't know if this is even an appropriate question. I know that with the nature of this offense, obviously, on behalf of the family, there will be significant objection to any parole being granted without him discharging the entire sentence. But does this court have the authority to grant some kind of a no contact clause? Should he be paroled, or should I reach out directly?
I think parole has to do that. I think I lose jurisdiction over any of that. And so that would be something that parole, if he makes it. And I think they can also sign up to be notified
we'll take care of that.
of any type of parole hearing, so that they could be present for that as well. So you're going to be handed again the certification that shows you can appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. Ms. Holmes?
Yes, Your Honor. I just wanted to address to the court with speaking with his family. They wanted me to ask, in the event whatever happens with him being sentenced, are there any tools as far as in TDC in regards to mental health?
Sure. So what happened?
His mental health issues.
Yes. The short answer is yes. The longer answer is typically when someone goes to TDC, they'll go first to the holiday unit, which is in Huntsville. They will be assessed for any type of issues that they may have. And then hopefully it's their, whatever issues they have, they will be sent to the appropriate facility where they can get help. But all of that, Mr. Bull, depends also on you. So there are all kinds of programs and help that you can take advantage of while you're in TDC, so that when you get out, you don't have the types of breaks, as you called it, or whatever's going on with making these decisions that you've been making, right? So you have to take advantage. No one can force you into programs. There are programs, but no one can force you into that. I hope you take advantage of it so that you can get out, live your life, and not be back in front of any other judge. All right. You can go back with the bailiff. No, sir. Go with the bailiff. I'm past done.
There's a court order that says that child is to be with the petitioners. If you interfere with that in any way, you are going to be in serious trouble, and I will be deciding what kind of sanctions are going to be imposed. You need to understand those sanctions can include money and they can include jail time. So between now and next week,
that.
I'm not asking you if you understand it. I'm telling you, we're not going to keep playing that game. All right. Next.
Your Honor, just to clarify for today,
yes,
she
sir.
needs to provide the child to the guardians today, as per the court order.
She needs to provide the child to the guardians immediately.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. All right.
Your Honor, you're breaking up when you just said that. I can't hear. I'm sorry. Everything's breaking up because I'm using a phone.
You are to provide the child to the ma'am. You're to provide the child to the petitioners immediately. We're over to the 26th at 10:30.
And the court order that has that on there, I get that at the office that you, the 360-577-3085, or that's where I get that order?
You can get that from the clerk's office.
Okay. I need to see that. Let's see that first. And
You're up.
Work on it.
We're going to extend the order through the 26th.
Can I ask a question, Your Honor?
You need to ask a question of your attorney.
No, you're not.
Emma Ryan, who's named after me, has been living with me since April this year based off of a coercive abuse issue with her ex-husband. And she's doing beautifully. She's involved in school.
Ma'am, let me ask you a question.
Okay.
Is there any paperwork from the state of California courts?
Yes, sir. I have an emergency protective order that covers myself, my husband, and Emma Solette Ryan against the Englishes and Jared Johnson. There's also another in Thurston County that also protects Emma Solette Ryan, as well as guardianship paper that was signed, Your Honor, and witnessed, and also is in the Superior Court of San Diego for guardianship for Emma. And all those things were sent to the attorney, and he has all of that. So she's been with me a good portion of the year, and she spends every summer with me. She has a play next week. She's very involved.
Okay.
Okay.
Guardianship of Emma Ryan.
Morning, Your Honor.
All right, counsel, here's where I'm at. I reviewed Mr. Goodday's motion. I've reviewed the response. I think what's going to happen is, number one, we're going to have to hold an evidentiary hearing to sort out the issue of where the child's been and who's got jurisdiction. Before we have that hearing, there's going to have to be a UCC JEA conference with whoever entered the order in California. I don't know if that judge is going to participate somehow or where that hearing is going to be held. But I think that's the procedure that we're going to have to follow.
Well, Your Honor, to clarify that there is no order in California. That's what this has come down to. I think the evidentiary hearing will show that the signed document and our findings looking in the court system down there has been no filing of a minor guardianship in the state of California.
Is there any kind of an order in California at this point, Mr. Goodday? I thought there was not necessarily a minor guardianship, but I thought there was some order relating to custody.
I think there was a no contact order, but Mr. Flay had recently told me that had been dismissed, so I'm not sure the status of that.
Your Honor, there was a protection order filed by the opposing party and her mother against my clients that was dismissed with prejudice from the San Diego court system.
All right, thank you. So we still need to hold, that makes it easier. We still need to hold that hearing. And I think Mr. Goodday is aware of my situation. Mr. Flay may not be. I'm covering this calendar for a short period of time just to help the county kind of with some personnel changes. So I think what I need to do is move this over to Commissioner Carmey's calendar, because she'll be the one in position to hold that evidentiary hearing rather than me. I'm just not available enough for them to be able to do that additional hours. So what I want to do is put this on next Tuesday at 10:30 on Commissioner Carmey's calendar. That would just to be to set a time to hold that evidentiary hearing that I think is necessary on the motion.
No objection from me, Your Honor.
No objection, Your Honor. Your Honor,
Tentatively, I did check with court staff about where that hearing could be put. And it looks like December the 11th at 9 o'clock, tentatively, subject to everybody's approval. But just take a look at your calendars for that. And then next Tuesday, the 5th at 10:30 in front of Commissioner Carmey, she'll be able to set the date for that evidentiary hearing.
Your Honor, is that, just to clarify, because it's evidentiary hearing, is that still going to be via Zoom?
I would assume so, given the physical differences or, just differences in locations involved. I think that's probably the best way to.
Understood. And just further clarification, Your Honor, the emergency guardianship is still extended for my clients.
We'll extend it through. I'm going to, just to avoid having to do too many more orders, let's extend it through the 11th, which I anticipate will be the date of the hearing. And if you'll send that order, counsel, if there are any problems with that on the 5th, Commissioner Carmey can sort those out.
Okay. And Your Honor, my clients, I believe, were working with law enforcement and outside of the state. If my clients are able to, I mean, they're the legal guardians for Emma, correct? So if they can get a hold of her, they should have her in their custody now, is my understanding.
Up through the 11th.
Okay.
All right. And if you'll get that order here, I'll sign it.
The letters or the minor guardianship order, Your Honor?
Yes, just extending the emergency.
Thank you, Your Honor.
All right. Thank you.
Thank you, John.
Court will note the appearance of Ms. Sharp on behalf of the plaintiff. The defendant is appearing in pro per. This is the time and place set for the evidentiary hearing on two matters: the plaintiff's motion for denial of parenting time for make-up parenting time, as well as plaintiff's motion for return of child and to enforce the orders. The court would note that the court had entered an ex parte order to enforce judgment of custody and to show cause for failure to comply back on July 25, 2023, which stated in the order in paragraph 1 that the defendant shall immediately return the minor child, Ella Joe, back, date of birth, to plaintiff for his parenting time. The plaintiff has subsequently filed an additional motion in this particular matter that was filed on November 27, 2023, stating that there has been an additional denial and that the child has not been turned over to him. Ms. Martinez, have you in fact complied with the turnover order in this matter? And I say that only because the most recent motion, the plaintiff had contained in paragraph 17 of the motion various texts from you, in fact, demonstrate or showing that you do not have the intent to comply with the court orders in this matter.
I did return Bella for visitations with her father until she was abused by her father physically. She came home with cuts to her mouth that were confirmed by her pediatrician, and then that is when I stopped.
Okay. It's my understanding from reading the motion that that CPS was involved and they did not substantiate. Is that correct?
They were at the doctor's office when the doctor showed them and confirmed to them the cuts on our daughter's lips. However, whether they followed their protocol for child abuse or not I'm not exactly sure.
Okay, well, I can only assume, I don't know, but I assume that they followed their protocol as they're required to do. Well, I guess the main point is, are you in fact refusing to turn the child over to the plaintiff?
Well, as of right now, yes. The plaintiff, Mr. Back, has pled guilty to domestic violence, which occurred July 1st.
That's the only point I want to make today, Ms. Martinez.
Yep.
As a result of your failing to turn over, as this court has ordered, the court is going to remand you to the Calhoun County Sheriff, where you will remain incarcerated until such time as the child is turned over to the plaintiff.
Okay,
So you can go with the deputy.
as I'm in court, how am I to allow the plaintiff to know where our minor child
Well,
is?
you're gonna have to make your phone call and make sure that whoever, where the child is, that the child is turned over, but at this point, you will remain incarcerated until such time as the child is.
But if I'm in jail, how am I supposed to get my child and give her to the plaintiff? I'm just trying to make sure that I know what to do from.
You'll have to call somebody or let the plaintiff know where the child is so he can pick up the child.
May I ask one more question?
Yes.
Because so we are gonna follow the current parenting time order, which is from the plaintiff gets our child from 8 p.m. to 8 a.m. So
The current orders have not been changed. They will remain in effect until such time as we have another.
so I am to turn our child over to the plaintiff at 8 p.m. tonight?
Is that, if that's the time of the
Yeah,
turnover?
well, yeah, that is the time of the turnover, yep.
Well, in this particular matter, I do note that the court has previously, and there are makeup parenting times that are required. Ms. Sharp, what are the makeup parenting times that you've requested?
Bring them up, Your Honor. My client initially went without the child starting July 5th, and I believe she started to comply back with the order. Was it in August?
I don't remember. She just placed me.
Okay, let me just look at my work. Quick. And then she stopped complying. She stopped complying November 3rd and my client has not had the child since.
Okay, so in total, how many days is that?
35. This time.
Yeah.
Last time.
29, the last time, 29 overnights, correct?
Yes.
Okay, and then from November 3rd until now, I'm sorry, just 1 second, Your Honor.
May I, Your Honor?
Just a minute. Let's figure this out first.
No. Are we minus that?
You need a calendar, Ms. Sharp?
Yes, I can bring a calendar, Your Honor. I can do it. Sorry, I was relying on his mom, which she's out there, and she knows all the dates. I was going to put her up on the stand to do it, and yeah, I understand. Okay, so the first time was 29, and now my client's stating it's 34 overnights.
34 total or 34 this time?
Additional.
Okay. So we have a total of 63, it looks like.
Correct.
Is the total. Ms. Martinez, is that square with your understanding?
Yes. Yes, it is. I was just wondering if the court was going to go by its recommendations that anybody that had pled guilty to domestic violence should not have 50-50 custody of the minor child because.
We are enforcing the orders that are in existence at this time.
Is the court going to investigate because of the domestic violence?
Other
the
agencies,
FOC handbook said it.
other agencies investigate, CPS investigates, the police investigate, the court does not investigate.
And I was just wondering, because the FOC handbook says that the court would investigate.
Court will order that the child be turned over to him immediately, forthwith, and that he will have the child for the 63 days that he has been denied as makeup parenting time. Yes.
I can have my ride here. Cindy, go get the minor child and bring her here within a half hour. She is only about 5 minutes from here. If the court can wait a half hour, I can have her here in a half hour.
Well, okay, I'll have the deputy take you. He can take you to the holding tank, and then we'll see that the child.
I'm sorry, should she bring Bella here to this courtroom?
Do that when you go to jail and figure it out.
I can. There's a personal protection order against him, and he continues to address me. When my friend Cindy goes to get Bella, should she bring her here to this court?
Bring her back to the court. In fact, what we'll do is we'll have Ms. Sharp and her client. They can be out in a conference room, and the child can be turned over to them. And at that time, once Ms. Sharp is confirms that he has the child, then we will allow your release.
Sure.
Okay.
Can you do that for me, please? Thank you.
has been turned over to your client, is that correct?
Yes, Your Honor, she's in the
Okay.
hallway.
Court will again reiterate that the child will remain with the plaintiff in this matter for the next 63 days for the makeup parenting time. And thereafter, the parties will then comply with the current order that's in place. Anything else, Ms. Sharp?
The only issue would be, Your Honor, is that the child goes to school and the school has given my client a hard time before because it didn't say that it was his parenting time at that time. It's going to be probably the next 7 days since I had to do a 7-day order for it to go into place. So there is concern that the child won't be able to go to school because he can't drop off and pick up based off of what they believe is the current order, not. So we just want to make sure she still can go to school somehow.
Oh,
yeah.
Yeah, and if you want to add that in the order in case, it's necessary, because you're going to have the child for 63 days, so you'll need it. So but the fact is that he does have opportunity or does have the right to take the child, pick up the child and be involved in the schooling. He would have that right anyway pursuant to MCL 722.30.
Yes.
Ma'am, don't shake your head unless you know the law.
I'm sorry, but the only reason why it's like that is because those are my parenting time hours. Mr. Beck doesn't have Bella during school hours. So that's why the school has that in place to follow the order to a T.
The law states that the non-custodial or the other parent, even if they're not a non-custodial, the other parent has the right to all information concerning schooling, doctor, etc.
Yes, they inform him about anything that goes on in the school, but just to follow the order to a T, he was not allowed to drop her off at school at noon or pick her up at 3:30 because those were not his parenting time hours.
We'll put that in the order, make sure that that's taken care of so that he is allowed to drop off, pick up, and do whatever's necessary for the schooling purposes.
Thank you.
Anything else, Ms. Sharp?
Just that probably in the next 7 days, because it will be a 7-day order, he probably won't have the ability to take her to school. And just my client just wants to, unless maybe mom can reach out and let them know. Or my client will try to reach out, but they won't follow anything without the order. So
That's up to that's up to the defendant.
Okay.
I'm not going to order that she contact the school or anything at this point.
Thank you, Your Honor.
Ms. Martinez, anything else that you?
Yes, sir. Can you tell me how this is in the best interest of the child, being that I'm a victim of domestic violence that he pled guilty to?
File a petition if you have.
Thank you, Your Honor. Thank you so much.
Okay. Court will end this matter at 3:00 p.m.
The report here states that was prepared by the probation office, which is very in-depth, that the complainant, the victim here, still remembers everything that occurred. Every time he passes by the location, he says, where this occurred, he's reminded of the severe beating he had to take. And he doesn't know why or nor understand how the defendants would attack him, because he would have helped them if they needed anything. The defendants took turns beating him with their hands and objects while his hands were tied behind his back. He says, while you were assaulting him, you had a look in your eyes as if though you were enjoying it. That you were kicking him in the head while he was on the ground. He suffered a fractured neck, a fractured back. His teeth were all loose, and he now needs surgery on his left eye. That's serious. I mean, that's just cold-blooded. Let me ask you, I mean, why have you ever been involved in kind of risky behavior before? At all? Never?
Yeah, like I said, I'm a church girl and bad situation.
Okay.
You moved back in with your parents and you're going to stay with your parents, aren't you?
Yes.
Because I'm not sure if that probably had something to do with the location where this occurred, those apartments. But that's speculation on my part.
Were y'all using drugs that night? Illegal drugs at all?
No,
Ma'am?
no, just beers. It was that's it.
So you pleaded guilty to this first degree felony of aggravated robbery, being a party to this. What did you do? What did you do wrong?
Judge, just for the record, she pled guilty to aggravated kidnapping.
I'm sorry.
Not
I'm looking at
aggravated
this.
robbery.
Aggravated
And
kidnapping.
I don't know that makes any difference. But
Well,
I
it's
want the record to be clear.
They're both bad.
Yeah, well, yes, sir. I'm not trying to say that. I just wanted to keep
You're right.
that clear.
I'm gonna put that aside. So on this aggravated kidnapping, first degree felony, what did you do wrong?
I realized that I should call it.
Ma'am?
I should call for help. Give me some help.
No, what did you do wrong?
I didn't stop it. I didn't stop it.
You didn't affirmatively do something?
Yes.
You didn't kick him like he said you did?
Yes.
Okay. While he was incapacitated, you were kicking him. Is that right or wrong?
Yes.
Why would you do such a thing? I mean, there were 4 of you. Was that enough people to hurt him? What do you think kicking the man in the head is going to do? You don't think that's going to severely hurt somebody?
Yes.
But y'all weren't using drugs or anything that night?
Not on my part. I'm not sure what they were on.
Okay. Have you ever had a problem with drugs at all? I'm just curious. Okay.
Although, Judge, there is a report, the probation officer asked her about drugs, and she did admit she has used drugs.
What?
In the past, and
what drugs? What drugs? What drugs?
It was a long time ago.
Marijuana and alcohol were the 2 that were mentioned, Judge, in the pre-sentence report. Yeah, but she did acknowledge that she did use drugs already.
Well, in the report, it says methamphetamine.
Yes, sir.
Encyclidine. PCP. What's used to embalm animals. LSD. Synthetic marijuana. All of those are hallucinogenics. They're terrible. But correct me if I'm wrong, but you have been hospitalized 20 times for this. This says you have a history of 20 hospitalizations, right?
It's not just for that one thing. I got in car accident when it was
For different things, but they include drug abuse.
No,
All of those are crime. Methamphetamine, PCP, LSD. Those are serious felonies.
That was the one time I was.
One time?
That was all on my system. That one time I went to Bental, I got in a car accident. And I was there for a while. There was a nurse.
No, wait. At one time, you had meth, PCP, LSD, synthetic marijuana, all in your system at the same time? I don't think so. That you would have never survived that.
My parents are in the audience. They can let you know.
They don't know. They weren't there with you. Were they? Did they see you ingest those drugs? Did they see you ingest those drugs?
Yes.
Well, then they wouldn't know the real truth, would they?
They were there when the doctor told me that it was in my system.
I just, ma'am?
I've changed them not that person.
Well, no. You committed this offense this February. God bless. What do you mean you changed? Are you changing for the better or worse?
For the better.
Well, this was terrible. You almost part of almost killing a man.
More embarrassing.
This is just a very cold argument. What's state asking for?
10 years, same as Ms. Volga.
Yeah.
Probation department says she set her trial in September. I'm sorry.
No, we just sentenced her. Anything else? If nothing else, I'm going to find in this case you have pleaded guilty to this serious first-degree felony of aggravated kidnapping voluntarily, knowingly, intelligently. See, what you pleaded guilty to is of intentionally and knowingly being a party to abducting the victim. And you committed that with the intent to facilitate the commission of robbery or to facilitate the flight after the attempt or commission of robbery by inflicting bodily injury on the victim. And it's just not bodily injury. This has to be all deemed as serious bodily injury, which is threat to his life. Well, your plea was entered voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement that, by the way, was fashioned to a maximum of 10 years in prison. But as you know, you are exposed to life imprisonment for this offense. Do you understand? I now find you guilty beyond a reasonable doubt of this serious first-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You will be given credit for all time you have served toward this offense. This was just not an assault. It was just not a kidnapping. This was a torture of another human being. That's inhumane. That I can't imagine treating another human being like that. One of God's creatures, and there, you did a terrible deed. The aggravated robbery will be dismissed.
Yes, sir.
As part of this agreement.
Sir.
Yes, ma'am.
You did an affirmative finding on Rebecca Pollard.
Well, she's can stand by. What are you asking for on the affirmative finding?
It was not a weapon used. Feet, hands and feet. No, actually feet, they kicked. You may not want to, I don't know, it's up to you.
It says inflicting bodily injury. It doesn't say inflicting serious bodily injury.
Yes, sir.
So an affirmative finding is not made that a deadly weapon was used for her. Ma'am, that makes a difference in parole.
In how much good time.
Plus, you're parolable in 1/4 rather than 1/2. That you would have been had I assigned an affirmative finding. So I'm not. You will be released earlier. Anything else? That is all.
I didn't want to make this video too long. I wanted to try to keep, rein on the amount of time. So I did, cut some of the videos just so that you could see the more interesting parts. And I'm going to try to post each one of those videos below in the description so that you could go watch that video if you wanted to. So if one of them grabbed you and you hadn't seen it, you're welcome to, go back and look. I love that. And I wanted to thank you all so very much for helping my channel this past year. You have been amazing, loyal and fun people to talk with. So I just so much appreciate you guys. I wish you all a happy new year. Thank you so very much for watching, and I'll see you next year.